Welcome to the first of the Cyber Academy Present series. It is run by the Cyber Academy at Edinburgh Napier University. My name is Basil Manousos. I'm an expert witness in digital forensics, and I'm the manager of the Cyber Academy. Today, I will be your host for this event. The Cyber Academy is part of the School of Computing at Edinburgh Napier University. We work with a wide range of strategic partners, including the Scottish Government, businesses, Police Scotland, the Law Society of Scotland, charities, and other universities and colleges. The Cyber Academy organizes conferences, symposia, and seminars that cover a variety of subjects in cybersecurity, digital forensics, incident response, cryptography, and blockchain, to name a few. The Cyber Academy Present is a new series of talks that brings exclusive speakers to our audiences. Our speakers set up their own agenda and talk about a subject that they are experts in, and it's something that's close to their hearts. Today, we're honored to have with us Ms. Laura Irvine, a pre-eminent Scottish lawyer with a vast knowledge and expertise in data protection. Laura is head of regulatory law and a partner at the Davidson, Chalmers, Stewart LLP. She's a criminal solicitor advocate, and she's accredited by the Law Society of Scotland.
Who's interested in privacy at the moment, and I do think that given that we are all now online a lot more, and when I say all, that's everyone from my 10-year-old son doing some schoolwork to my aged parents who are locked down far away from us, and all of us are using new technologies a lot more, and our presence online is much, much greater. So privacy becomes an issue in relation to that. So my title is New Technologies and Privacy in the Time of COVID-19. It applies to other times as well, but I just think the issues have been heightened given where we are and how much activity online we're all taking part in. I thought I would start with an example, and it gave me an excuse to use an image of Fortnite. Now, Fortnite has been a big feature of my lockdown because I have a 10-year-old son. You may hear some screaming in the background, and that will be him murdering people with his friends online because he plays Fortnite most afternoons after homeschooling is finished. So this is the latest group of characters from Fortnite, and yes, I know all their names because I have to talk about them over dinner. However, how is this relevant to new technologies and privacy? I will explain. A friend of mine contacted me a couple of weeks ago in a bit of a panic, and she has been involved in setting up a new online platform which is aiming to provide interactive conferences, and this has been developed in response to lockdown so that people can still do the networking that we all expect when we go physically to a conference, and also that it's much more of an immersive experience than just a series of webinars that we all sit in front of our screens and watch. Therefore, she bought herself a PlayStation and has started to play Fortnite to get that immersive gaming experience, so that she can try and copy that within a conference setting. So that was my feeble excuse for the image of Fortnite in these slides. This platform then is the focus of the first example that I wanted to talk about today. The platform is run by a company. All of these companies shall remain nameless, and they were commissioned to run a conference for quite a significant organisation, not a public sector organisation, but an organisation that's very much funded by the public sector and runs on a public sector ethos. So there were about 60 delegates had signed up for this conference, and during the sign-up process, of course, they gathered personal data, including contact details, and those details were shared amongst the delegates so that they could talk to each other and continue conversations after the conference. Now, what was also collected at the request of the conference organiser was information about equality monitoring. So this organisation has quite a sophisticated diversity and inclusion programme, and therefore they wanted to know a little bit about the delegates that were attending their online conference. So information about ethnicity, sex and disability was also gathered by the platform. Now, late one night, one of the developers who was based in the US discovered that not only was the contact information available for the other delegates to see, but also this equality monitoring information. Now, that was information that was what we would call special category data in terms of data protection law, and it should not have been seen by the other delegates. So my friend phoned me in the morning in a bit of a panic, saying, what on earth, what are the issues here? What are the problems? We need to speak to the conference, the people who were putting on the conference, their client, we need to speak to them, we need to tell them about this, but I just want to have a sense of what the data protection issues are before we do that. So this was before we really knew what had happened. All we knew was special category data had been made available, accessible to people who should not have seen it. And that information was attributable to the individuals who attended the conference. So these were the kind of questions that immediately ran through my mind. Who's the data controller here and who's the data processor here? And that's significant because the obligations are very different in relation to both of those entities. So the data controller here would be the conference, the organisation hosting the conference. The data processor is the technology company providing this interactive online platform. So that's the organisation my friend worked for. So they don't have, the data processor doesn't have an obligation to report this breach, but it must, to the ICO or to any of the individuals themselves, but it must report to the data controller. And obviously they want to do that in a way that demonstrates that they know what's happened and exactly what the issues are here. I also asked, was there a contract in place between the platform provider and the conference host? And I understood there was a contract and that there were particular data processing terms within that, but the content of that contract would have been significant in terms of apportioning liability should there be consequences there. So that was another question. My first intake of breath was because this issue involved sensitive special category personal data. And I wondered, well, why was that collected in the first place? Was there a good reason for that to be collected? And why wasn't it anonymised straight away? Why could it be linked to the individuals who were attending that conference with the inherent risks that that brings? And my biggest question was, well, surely that could have been captured in an anonymous way. And therefore, there wouldn't have been any data breach at all, because that anonymous data would not be personal data, and therefore the GDPR, Data Protection Act, would not apply. And then I wanted to know what the individual delegates had been told. Were they told that this special category data was being collected about them and it wasn't going to be anonymised, but here's how it was going to be used? And what other information were they given about the data that was being collected? Did they know that there was a third party involved, i.e. the company my friend worked for? And or would that come as a surprise to them? And then finally I asked, well, was there a data protection impact assessment? Now, my friend wasn't in a position to answer all these questions, but she needed to know what the conversation was likely to be with their client, and who was the host, and was a client that they wanted to do more work for. And I just thought this was a really interesting example of something that was aiming to take COVID-19, take a lockdown, but let's try and make sure that we continue to interact in the same way as we do by using some clever technology. And I don't know all of the things that were involved in this technology, but it's innovative and immersive, I don't think they had to wear those Fortnite outfits, and I definitely don't think they were shooting each other during the conference, but there was an immersive feel to it. So really positive piece of technology. But this issue had arisen with this information being shown and available to the wrong people. And that was a very simple matter that should have been thought about in advance and could very easily have been dealt with without that possibility even being a risk. We'll come back to this example a wee bit more when I talk about all the different topics that I want to go through today. But I thought it was a good, simple example of where things can go wrong, despite everyone having the best intentions for making things work in lockdown. The next example, of course, is the track and trace app that the government has been developing. Now, I know it's very difficult to remember times at this stage, but I think it was at the beginning of May that this track and trace app was announced in the UK. It was being trialled in the Isle of Wight first, and a data protection impact assessment in relation to that trial was published. And we'll talk a bit more about what a DPIA is for those who maybe aren't as familiar with those terms. But that effectively was setting out what the risks are and how they would be minimised. So track and trace app will all know something about the proposal, and they're being used globally to try and help ease us out of lockdown. So nobody can dispute that that's a good aim. However, there were so many questions about this app that arose at the time and that were not addressed within the DPIA or any of the documentation around the app when it was launched at the beginning of May. It was interesting. I read all of that with great interest. At that point, I went back and read the documentation yesterday when I was preparing for this, and there's been some significant changes in the proposal. Many of you will be more interested in the technical security side, and I know that there have been well publicised challenges in that sphere as well. But fundamentally, here's a piece of technology that could help us out of lockdown. But in order for that positive outcome, we would have to give up some privacy in order for it to work. And that's the balancing exercise that we need to make as individuals when deciding whether or not to use this app. Now, it was pitched as being voluntary, and that sounds fine. So only those who want to sign up to use it needed to do so. However, there were concerns voiced about would it really be voluntary, or would the outcome be that if you don't have the app, you're not getting in, whether that's into your office or whether that's into a restaurant or a pub or any kind of space that you want to enter. So there were questions about the true voluntary nature of it. I put some of the questions up on that slide. The first thing that leapt out to me was that the data they claimed that the data was anonymised. Now, that was absolutely never going to be the case. The data controller in relation to the app has actually changed over the last few months. So now it's the Department for Health and Social Care, under which, of course, lies various NHS bodies. So originally, I think it was NHSX that was named as the data controller. And there was absolutely no way that that data was truly anonymised in terms of the GDPR standards that would require that these organisations could identify the individuals if they wanted to, and there would be certain identifiers that would link back to the individual, whether it was their device or them as individuals. So that concerned me as soon as I read that in the DPIA, and it does not engender trust in relation to those running that app if they're claiming that the data is anonymised. Was it based on consent? And that seemed to be suggested when I first read the documentation. However, when I went back yesterday, they have set out the legal basis for processing data in the app, and those are public. It's a public task, and they also talk about the legal basis for processing special category data, so any of the health data that again you would give to that, it's processed on the basis of particular legal rights that organisations have to process data in times of public health crises. Therefore, it's not based on consent, and if you withdraw that consent, they can keep that data and they can keep processing that data. And even if you delete data off your phone, if it's been passed down centrally, then it can continue to be processed, whether you consent or not. So again, another question that it would have about the documentation. Was there special category data being processed? So to some extent, you were asked to self-report symptoms and diagnoses if you had been tested. So yes, some special category data was being processed through the app. Who had that data? Interestingly, again, initially the third parties who were helping were not named. Now it appears that it's Microsoft and Amazon and a couple of other organisations who are providing the technology in the background. They're what's called data processors. So I've mentioned that already, and that's something else we'll talk about a wee bit. How long is the data going to be kept? It now says 28 days for the data on your phone, but if you do report symptoms and there's further processing that goes on, then it isn't clear how long that data will be kept. And one of the statements, which I thought was quite interesting, was, well, we don't know how this virus is going to develop, therefore we can't give you a time scale as to how long we're going to hold on to that data for. And that also applies to how that data will be used and shared with other organisations. So at the moment, there are clearly defined purposes for the processing, and they are all related to COVID, but they are drafted quite broadly, and therefore the uses that data can be put to and the future uses as the virus develops and as the government's reaction to the virus develops could be much broader than those set out at the moment, and that is more than hinted at in the documentation. And all of that is, were the questions that were being asked before you get anywhere near security and how secure is all of that data. And therefore, I found it quite interesting that these were the questions that not only my community was asking in terms of those who are interested in privacy, but for example, I got a WhatsApp message from my brother when it was announced saying, surely this isn't right, can we do this, blah, blah, blah. So I think these questions are being asked more and more by people who perhaps weren't as interested in all of this kind of technology and privacy prior to lockdown. COVID has heightened this. So these are very good questions, very valid questions, and the sort of questions that the privacy community would be asking in relation to all technology. But I think the COVID app was again a good example of where those questions were being asked by everyone in the community who was looking at the app and wondering what would happen. And partly, sadly, these questions were asked because trust in those administering that app, and essentially the government, has not been at the highest levels over the whole duration of lockdown. And particularly, you will remember there was a particular trust incident which had headlines around about the time the app was being talked about, and it really has diminished the trust that people have in the government and diminished the trust, therefore, that people have in giving them data. I did notice that yesterday it was announced that the Norwegian app had been binned effectively because their data protection regulator had said, well, actually, we don't think that you can balance the invasion of privacy against the effectiveness of this app. And that's the bigger question, you know, how effective is that going to be in allowing us freedom to get out of lockdown? We're giving up some privacy. What are we getting in return? And again, I don't think these questions were clearly answered in terms of the effectiveness. So it's been delayed. It's not coming in until, or use of the app's not going to start in England until the end of June at the earliest. So we will see where the government gets to it, but I do think that that issue, trust, is the biggest problem with the app, and us handing over quite sensitive and invasive personal data to that organisation that some of us no longer have much trust in. So the topics that I really want to focus on today, and these are kind of headline topics that I think are relevant in terms of new technology. Other lawyers would have a different take on this. But for me, these are the important questions to ask, and both the examples that we talked about highlight them eloquently, and I think highlight the use of technology and how any organisation that's developing technology, whether a data controller or a data processor, really has to be aware of these issues, because in order to get people to use your product, you need to gain their trust. And I think people are going to be asking questions more and more. So they have been after the introduction of the GDPR, or certainly in the run-up to that, privacy issues hit the headlines in a major way. And I do think that the lockdown and the use of technology during lockdown has also meant that people are more aware of privacy and are more likely to ask questions when they're asked for personal data. And therefore, you or the organisation developing new technologies must be able to answer these questions in an accurate way and in a way that is easy to understand, but is transparent, and that just tells people what is happening in simple terms. And I use all these terms as a data protection lawyer, but what I want to try and do is move away from jargon today and really try and use simple terms to explain what is a DPIA, what is anonymised data, and just to talk about in practical terms what the issues are, why people trust some organisations and don't trust other organisations, how you can be transparent, and how best to get that trust so that you can then get people to use your technology in a way that means that they're willing and happy to do so. So personal data and anonymised data, we'll talk a bit about that. I want to talk about data processors and data controllers because they are highly relevant in terms of technology. DPIAs, data protection impact assessments, what the heck are they? And they will be increasingly important as we go forward. And then privacy notices, and the DPIA feeds into the privacy notice. That's telling people, explaining to people what you're up to and getting that trust. So personal data. I think I hope most people understand what personal data is. It's not an easy phrase to define, but it's information from which an individual can be identified. So there's some that's very clearly personal data, so your name, your address, your telephone number, anything that identifies you, photographs, images of you from which you can be identified. But also information that relates to an individual. So that's also encompassed in the definition of personal data. So it can be anything with a biographical significance. You don't need to be named in that, but if it relates to you and someone can identify you from that, then it becomes your personal data. Sometimes that's contextual, it depends whose hands that information is in. So defining personal data can be broader and can be a little bit more tricky than just pointing to something with someone's name in it. It includes, of course, information on paper, only when it's in a relevant filing system. We're not dwelling on that today because what we're interested in is the digital information used by new technologies. Online identifiers are personal or can be personal data. And of course, that's something that has become much more prevalent. We're all using online technologies more, as I said at the beginning, and it doesn't. That these technologies don't need to capture our names in order for them to hold personal data about us. So they can have some clever identifier, and we all know many technologies that do this. But that's under that identifier, there's lots and lots of information about you as an individual that allows that organisation to perhaps target you with advertising, or contact you in a particular way because they think they understand you. So all of that is personal data, and it's very difficult sometimes to explain what's going on in terms of, particularly in the ad tech sector, what's happening with that personal data. Tracking is another issue, back to the COVID app, that is particularly invasive, and mobile devices have allowed that to happen more and more as we live our lives online. So personal data has a very broad definition. I wanted to talk about anonymised data because it is a term that is used within the GDPR. And if data is truly anonymised, then the GDPR doesn't apply. And it's very useful if you can genuinely anonymise data. And that can be very, very challenging because if it can be re-identified as relating to an individual, then it is not anonymised. The test that's set out by the ICO is on that slide. So if the organisation that has this information, which is anonymised, if they could still identify someone from the details or combine it with other information that they have, it will still count as personal data. And that other information could also be information that's reasonably available to them. So it's very difficult for the government to claim that they have anonymised data, because often they will have information available to them which allows that data to be related to an individual and to identify that with another individual. And you really do have to think about whether or not it is truly anonymised. But it is obviously very useful if it is. The risks for the individual are minimised and the GDPR doesn't apply. And in terms of any breaches happening, so we'll go back to the online conference platform, if that data had been anonymised and kept separate completely from the information about the delegates, then if it was accessed, there would have been no data protection issues there because it was truly anonymised. So anonymised data is something always to think about when you're developing technologies. Do you need personal data, or can your aim be achieved just as effectively with anonymised data? And in the case of the online platform, that was really all about statistics and engagement from individuals who didn't need to be identified. They just needed the numbers of people attending the conference from those different criteria that we had asked for. The next issue that I wanted to talk about then was this difference between a data controller and a data processor. And particularly when we're talking about technologies, you will tend to have a data controller who uses lots of other third parties to help them achieve their aims through technology. So let's have a look at the app, the tracing app. The data controller there, the Department for Health and Social Care. So they were the organisation that was responsible for saying, right, here's the data we want, here's why we want it, and we are going to determine what is done with that data. So we're in control of that. And we want to set up this app, and we want, therefore we want to allow people to download something onto their phone. We can't do that, we don't have the skills to do that, so we need third parties to do that. So those third parties are the data processors. They are not employees of the data controller, it's a separate entity, and they process personal data. So they use the personal data, they have it, but they only do that on the instructions of the data controller. So they don't decide what to do themselves. So Amazon Web Services is one of the third parties that's helping the department in relation to the app. So Amazon will have that data. They're storing it, I think, on the cloud. I think that's probably their role. But they won't be doing anything on their own account. with that data. They won't be adding it to their analytics. They will just simply be storing that data because they are a data processor. And therefore that function is limited, and they can only act on the instructions of the controller. So these are the two different types of organizations that we have who will process data. And I wanted to talk today about the processor, because I think that data processors are sometimes like the poor relation of the data controllers. And actually the GDPR brought in quite a number of additional obligations on data processors. So these are organizations now have to be much more aware of what the GDPR, what the Data Protection Act says they have to do, and what their obligations are. And particularly in terms of new technology, data processors. So my friend's company who set up the online platform, they needed more awareness of what data they were capturing and why. And they needed to be asking these questions before something went wrong, not afterwards. And part of that is so that the conference host, for example, trusts them as a provider, and can then make sure that they are getting data protection right when actually what they're aiming to do is put on a conference, but the data processor could engender a lot more trust with their clients if it gets data protection right and asks the right questions from the beginning. So this is just a reminder then of the obligations, the obligations that came under the GDPR. Data processors and data controllers must have a contract. There's lots of different things in that contract, but the biggest one is what data are you giving to the data processor? What does that data processor then do with that data? How long will they hold on to it, and what will they do with it at the end of the contract or the project or their dealings with the data controller? And that has to be set out so that the data processor knows what it should be doing and what it shouldn't be doing. Very simple instructions. And one of the things that the ICO will do if there is an issue with a data controller and a data breach that's been caused by a data processor, they will come in, and it will be the data controller who has the obligation to report that breach. They will come in and say, okay, where's your contract? And if you don't have one, if the data controller doesn't have one, then that's one black mark against the data controller. And actually that can result in an additional penalty if the organization is fined. And similarly, the data processor can also be fined. Whether or not that will be because they haven't assisted in the contract, time will tell, but I can see that happening. So both organizations need to be aware that they have to have this written contract in place. In addition, if the data processor is using any subcontractors, sub-processors, they have to have an equivalent contract in place with the sub-processors. And that is something where the obligation is definitely on the processor to make sure, again, that written contract is in place. So many data processors developing new technologies, they will be using third-party processors. So for example, Amazon Web Services to store the data. They may have other databases. And therefore, they have to make sure that there is a written contract in place with any sub-processors. And the controller has to authorize them using sub-processors, so that can be done in a blanket way, but you must always tell the controller who you are using as a sub-processor. The controller needs to have that information in order to maintain control. The processor has different obligations in relation to security as well. So just the same as the data controller, if it messes up, it can be fined if something goes wrong in terms of security. And not only that, but with civil claims on the increase in terms of data breaches, it's quite likely that if it was the processor that was at fault, any claims which are lodged against the data controller will find themselves on the lap of the data processor. So security is a very considerable issue, and one that under the old data protection regime fell only to the data controller, but the processor now has their own obligations. Processors also have to have a record of processing activities, so this is an obligation that was introduced by the GDPR, you need to document what data processing you are doing. And again, that's something the regulator can ask for. Some data processors will have to appoint a DPO, so any public sector processors or any processors that who are processing lots of special category data or carrying out profiling. Processors must also think about any international data transfers. So just say one of your sub-processors hosted a database in America, you would have to make sure that adequate protection was in place if the controller's data ended up outside the EU. We'll not talk about Brexit at the moment, but that will become more complicated. And then finally, as I said, processors can now be fined by the ICO and also sued for compensation by data subjects. So the obligations of the data processor have changed significantly under the GDPR. And I think sometimes it's missed, and particularly in these times when we're getting all of these technologies up and running quickly to respond to COVID. I think the example of the online platform was a good one. I don't know the outcome of the investigation there, but I suspect that all of these things were not in place. It's also significant to note that there are certain things that processors are not obliged to do. And again, this is something that's missed. So it's not the processor who reports a breach to the ICO or the data subject. That is up to the data controller. So the organisation that effectively has the relationship with the data subject. But the data processor must tell the data controller about any breaches without undue delay. And effectively that means as soon as they find out about it, they have to tell the controller. And it's then up to the controller to decide whether or not to report any further. I dealt with a case quite recently where I was helping a processor, and it was quite an interesting position to be in because we had very little information about the Information Commissioner's investigation. And certainly to date, we've not been asked to provide the ICO with anything on our own behalf, but we can still be fined at the end of that investigation. So it'll be interesting to see how that pans out, which will be post-lockdown because the ICO is concentrating on other things at the moment. Data processors also don't have to comply with subject access requests or any data subject rights in relation to the data they're holding on behalf of the data controller. They do not have to carry out a data protection impact assessment on their own behalf, but they should assist the controller to carry one out. And as I was saying earlier, I think a responsible data processor should be pushing a data controller about DPIAs, particularly if there's any special category data involved. Data processors don't need a legal basis for processing. They don't have to comply with the principles. All they do is obey the instructions from the data controller, and it's the data controller that has all those other obligations. So quick whiz through controller processor issues. Right, data protection impact assessment. So I think these are seen as a bit of a black art. It's a risk assessment about data. In a health and safety setting, we're kind of used to risk assessing, like what could go wrong and what can we put in place to make sure that it doesn't go wrong, or if it does, the risks are much more minimal. And that's essentially what a DPIA is as well. What processing are we doing? What data are we processing? What could go wrong, and what can we put in place to make sure that the impact of that is minimised or taken away entirely? So, helping you reduce the risks. You must do a DPIA in certain circumstances, and that's defined as any processing that's likely to result in a high risk to individuals. That just means damage or distress. And if anything goes wrong, will that cause damage or distress? And there's a nice list that the ICO have produced of when they expect the data protection impact assessment to be carried out. So think about any special category data, biometric genetic data, they're very concerned about that, any profiling which results in significant decisions being made, or really egg processing, that if something went wrong that could result in harm to individuals. Carry out a DPIA, see if you can minimise those risks. So this is what I think a DPIA is. This is in non-technical language. What on earth does a data protection impact assessment try and do? So there is a template document available on the ICO website. I find it quite repetitive, and it feels like you're answering the same question every time. But essentially what you're being asked is, what personal data are you using? Why are you using that? What is it you're trying to aim? Think about whether or not you need to use personal data at all to do that, or whether you need all of that personal data that you have outlined in your project. Do you need all of it? Could you reduce that amount of personal data and again, minimize your risk? You need to include any data processors, as I was saying before. So identify those organizations that are going to help you, particularly with new technology. Understand what they're doing, and yes, that can be challenging, but you, as if you are the data controller, you need to do that. You need to understand what they're doing in order to get to the next stage. Is your processing necessary? Do you need to process personal data? Do you need to process all of that personal data? And is it proportionate? You need to think about the principles, the data protection principles, and the next slide runs through those. Identify the risks. What could go wrong? And if something does go wrong, how bad is that going to be? So go back to my online conference platform. The names and addresses, the names and contact details of individuals attending that conference, they were shared amongst the delegates. That was expected. They knew that was happening. There was a privacy notice that explained that was happening. And that was all to try and replicate the experience they have when they attend conferences, and it was breakout rooms and things where they could speak to each other and then contact each other afterwards if appropriate. However, that sensitive data about their ethnicity and disability in particular, and sex, that's the kind of information that you would not expect to be readily made available to other delegates, and therefore, if the other delegates had that, would that distress you as an individual? And these were the kind of the thoughts that the data controller there, the online platform provider, and the conference organizer had to think about. And was it likely to cause those individuals distress? And that's very contextual, but that needs to be identified in advance. And therefore, how could you have eliminated the possibility of that happening? Anonymise that data. I think that was the simple answer there. And then finally and crucially, record all of your thinking in terms of that risk assessment. And even if your thinking is, I don't think we need to do this DPIA, record that somewhere so that you can justify, be accountable for that decision later on. If something does go wrong, then you can say, actually, here's our thinking, and here's how we minimised it. It could have been a lot worse, but look, we were data protection, for example. Here's the data protection principles. So hopefully these will be mostly familiar to you all. All of these things have to be thought about, and they're built into a data protection impact assessment. What's your lawful basis for processing data? Is it fair, and are you telling people what you're doing? Being very open about what you're doing. And often if you think, actually, I don't want to tell someone that I'm sharing the data with Facebook, for example, then you need to think about whether or not it's fair that you do that in the first place. So transparency is a really good method of assessing fairness. That's all about privacy notices, and we're coming on to that. Limit the purpose for the processing. So yes, I'm getting your contact details to share with the delegates, but they won't be shared any further, and they will only be used by those delegates. Identify that purpose in advance, and again, communicate it to people. But that would be built into data protection impact assessment. Data minimization. So I've already mentioned that. Do you really need to collect that bit of information? What's your basis for doing that? And can you keep that the bare minimum that you need for the purpose? Think about that in advance and identify that, and identify what's proportionate to collect. Keeping your data accurate. that's something that sometimes is not relevant if you're just storing it for a short period of time, but it's one of the principles that you need to be thinking about if there's ongoing processing. Storage limitation, how long are you going to hold on to that data? And it's really important to identify that. One of the privacy notices, it wasn't the app, but for the track and trace, the physical track and trace processing, the privacy notice said we were going to hold on to the data for 20 years, maybe for research purposes. It was very vague and completely unnecessary. Nobody could understand why 20 years had been chosen. And therefore, identify that in advance and think about it. And it's not an easy question to answer, but generally with clients, when I talk through the issues, they come up with a figure that's sensible. And then integrity and confidentiality is security, and I'm not going to talk about that too much in this session. And then accountability, demonstrate compliance, write everything down, built into a data protection impact assessment. And that's really why they're so important. And we need to build them into all new technologies that are being developed and all new data processing that is being carried out. Very briefly, privacy notices. So that's telling people what you're up to. And as I've said, I think throughout, I think privacy notices will become more and more important to data processing and to making sure that your clients and your customers trust you and are willing, and are therefore willing to give you their personal data. And I think more and more we need to get better at privacy notices. And actually, take away the jargon, take away the we take your privacy very, very seriously nonsense. There's no need to say that. That's an expectation that everyone has, and you don't need to set it out. Just tell them what you're doing in a clear and transparent way, and in a way that anyone can understand. That's all the stuff that needs to go into the privacy notice. And as I keep saying, I do think that transparency is going to become more and more important in terms of data processing, and to make sure that all organisations, whether it's the government or whether it's a small tech company developing a new app, whether consumers, individuals, data subjects will trust that organisation with their personal data. People are getting more careful, and people are much more informed about what these issues are. So go and read that privacy notice for the COVID track and trace app. I think it's a really useful exercise. If you're developing a technology, go and put yourself in the shoes of someone, and that app could apply to all of us. Go and have a look at it. What are the questions that you come away with after you've read it? Apply those to your data processing and your new technology. Put yourself in the shoes of someone that's reading your privacy notice and think, actually, I want to know that. It's easy for me to see that. And that's a really good way of becoming transparent and engendering trust. Yeah, and then just finally, slide that I tasked my husband to create me a road sign, and it became a little bit more complicated than it needed to be. But essentially what I'm saying is, with new technology, just because you can, doesn't mean that you should. And that doesn't mean, and I don't like data protection to be seen as something that stops you doing stuff with new technology. But what you can do is do it better, do it more responsibly, and do it with less risk. And the best way to get to that position is to stop, to think, and to write it down, to maintain that accountability principle that the GDPR has built in. And those lessons, those headlines, those tips that I've gone through today will hopefully help you to address any of the issues in advance that should be addressed, so that if something does happen, if there is some kind of incident where there is a data breach, you will be able to say, well, look, we thought about that, we minimised this, we did everything we could to try and prevent that happening, and actually just, mistakes do happen. But here's why you can trust us. So that is the end of my slide show, and I'm going to stop sharing my slides now and come back into the room. And I'm happy to take any questions or comments or observations that you have. And I can't answer many questions about the track and trace app, but I think personally it's not something that at the moment I would be signing up to use.
Thank you very much, Laura. That was a very interesting and stimulating presentation, and I'm sure we all learned a few things. I surely did myself. As mentioned earlier, the QA session will not be recorded or included in the final video. I would like to thank you all for attending, and especially Laura for giving her time and knowledge to this very first of the Cyber Academy Present events. Please keep checking our social media and our website at www.thecyberacademy.org for more updates on upcoming events and training. Thank you all for joining us today. I'm looking forward to seeing you soon. Bye-bye.